Mark Adams. He's going to be talking about unfairness and abuses of process as evidence of judicial misconduct. And after Mr. Adams, we have Dale Nathan, who's going to be talking about looking at and beyond your record for evidence of judicial bias, collusion, and coordinated judicial wrongdoing. Now, they are slated to moderate an audience discussion about real-life problems in the court. And at that point, I'm hoping that Ms. George will jump in and join in that discussion and help us talk about real-life situations where a judge is doing something right in front of us that may suggest judicial misconduct. Okay, so at this point, Mr. Adams.
Thank you. As Zena said, my name is Mark Adams, and I'm here to talk about, or I was asked to speak about unfairness and abusive process as evidence of judicial misconduct. First, I want to thank Zena Crenshaw for her efforts to form the National Judicial Conduct and Disability Law Project, for her efforts to put this judicial reform conference together, and for her efforts to expose the problems in our court system and push for needed reforms. And most importantly, also for inviting me to speak at this conference. I really appreciate the opportunity to talk about this issue. Also, I want to thank Rice University for hosting this conference. And I want to thank the other speakers who have the courage and integrity to speak out about the problems with our court system and to push for necessary and long overdue reforms. Reforms that are absolutely necessary if we truly want liberty and justice for all in America. Finally, I want to thank those of you who took the time to attend this conference and those who are taking the time to watch this video. I truly appreciate your interest in learning about your rights, about our court system, and about the things that you can do to help restore justice in America. I'm an attorney from Florida. Sometimes it seems like Colombia or Mexico. I'm sure many of you from other states feel like you might be operating in a third world legal system. I earned my bachelor's degree in business administration from the University of South Florida, with a major in finance and a minor in economics. I earned my law degree and my MBA at the University of Florida. They not only have great sports programs, we are the national football and basketball champions right now, go Gators. But also, University of Florida's law school is consistently ranked as one of the best public law schools in the country. It's also considered to have one of the best business schools in the country. While earning my MBA, I worked as a teaching assistant in the economics department. And economics is one of the most important disciplines to be educated in. Better helps you understand the forces that shape society. Some of you may know me from my work on election reform or on media reform. These go hand in hand with judicial reform because if our votes are not counted accurately, then we have no power to elect leaders who will act in the public's best interest to ensure a just court system. And if the cartel that controls the media in our country will not expose election fraud and will not expose judicial corruption, then that cartel needs to be broken up, or we need to turn to new, independent, and more trustworthy news sources. Our country's founders realized that a free flow of information is absolutely necessary to preserve democracy. This is why they protected freedom of speech and the press, and why they required public trials. They understood that the public needs to know what our government is doing. They knew that an informed and empowered public was the only way to prevent tyranny and protect liberty and justice. Most of us have heard the saying, no justice, no peace. In fact, many of you have probably chanted that at a rally. Some may think that it's a threat, but it's not. It's the truth. Without justice, there can be no peace. The Florida Supreme Court has said that if a man cannot find justice in the courts, he is likely to seek justice in the streets. However, vigilante justice is just one of the problems caused by a failure to find justice in the courts. Without justice, there is no peace, because at any moment, your life can be turned upside down. At any moment, your job, your property, even your children can be taken away from you. Your only choices are to fight back and quite possibly lose everything, even your life, or give the man with the power whatever he wants. Without justice, you cannot find peace unless you are a member of one of the privileged classes. And even then you have to worry about crossing paths with someone with greater privileges than you. Without a court system that will protect your rights and give you the same treatment that it gives every person, you have no rights and no justice. If the court system gives some people special treatment and you end up crossing paths with someone from one of those privileged classes, they win and you lose. If the law is not applied equally, it's not fair or just. When the law is not applied equally, there is injustice, there's tyranny and oppression. Without justice, there is no peace. There is only anarchy. Many leading economists believe that America's justice system is one of the main reasons why our country grew so much more quickly than others and came to be so prosperous. Of course, there has always been injustice in America, but our system was just more just than others. And that is what encouraged Americans to invest time, effort, and financial resources in economic endeavors. They made these investments because they felt that their investment would be protected and they could reap the benefits. However, those who suffer from an unjust government do not have the same incentive to make the investments that lead to a better life, because they know that at any moment their investment can be unjustly taken from them. Our founders understood this too. They had seen what could happen when people in government had too much power. They knew that it would lead to abuses, and the abuse did not just hurt the people who lost their property or their liberty. Our founders knew that it hurt everyone. This is why they tried to put a system in place that would ensure that people were treated equally and fairly. Our founders designed our system of government to try to protect us from abuses of power. They had experienced tyranny where the king, his judges, and his ministers could change the law at their whim. And they wanted to design our system to protect us from tyranny, both that of a dictator or king and that of the majority. To do this, they designed a system of checks and balances, which includes the three branches of government: the press and the public through elections, the right to assemble, the right to freedom of speech, the right to petition for a redress of grievances, and through jury service. Our founders intended to continue the protections afforded by the grand jury. The Fifth Amendment requires the government to present evidence showing probable cause to convince a grand jury to issue an indictment before charging someone with a capital or infamous crime, which is also known as a felony. However, the Fifth Amendment has since been interpreted as only requiring the federal government to seek grand jury indictments. When our Constitution was ratified, the public prosecutor, as we know it, did not exist. If your cattle were stolen and you learned who did it, you petitioned the court for a redress of grievances, and the court summoned a grand jury to hear you present evidence that your cattle were stolen and who did it. If the grand jury found that you presented evidence showing probable cause that a crime was committed by a certain person, they would issue an indictment which allowed you to prosecute the wrongdoer in a criminal trial. Our founders intended to protect the citizen's right to petition for a redress of grievances so that you could present evidence of criminal conduct to a grand jury. You didn't have to go to a gatekeeper. They didn't have gatekeepers then. Imagine if you could show a grand jury that a judge ignored the law or the facts to rule in favor of the opposing party. Do you think that a grand jury would find probable cause that the judge had been bribed? Would you? Unfortunately, your constitutional right to present evidence to a federal grand jury was taken away in 1946 when the Federal Rules of Criminal Procedure first provided that only a United States attorney could present evidence to a federal grand jury. This important right still exists in a few states, but it's not taught in schools, even law schools, and therefore it's rarely used. Just take a moment and imagine how quickly justice could be restored if a judge had to fear being indicted if he ignored the law and threw a case. Our founders provided in Article 3, Section 2, and in the Sixth Amendment, that all criminal prosecutions shall be tried by an impartial jury. And they gave us a right to a jury trial in civil cases. They intended that the jury decide both what version of the evidence was to be believed and whether the law, which the parties were asking to be applied, was just. The founders envisioned the jury to be the ultimate check on the power of the state and the ultimate protection against injustice. As Patrick Henry said, why do we love this trial by jury? Because it prevents the hand of oppression from cutting you off. This gives me comfort that as long as I have existence, my neighbors will protect me. Alexander Hamilton said that juries make bribery more difficult because there is always more time and better opportunity to tamper with a standing body of judges than there is to tamper with a jury summoned for a trial. However, the jury's role has been undermined because now judges routinely tell jurors that they have to follow the law as explained to them by the judge. And the United States Supreme Court has said that you are not entitled to a jury trial unless you are charged with a felony. Our founders required public trials so that the public would know if a judge was acting improperly. They protected freedom of the press so that the press would inform the public of government wrongdoing. They understood that if a judge was subject to public scrutiny, the judge would be less likely to act improperly for fear of being shunned by his neighbors. Now there's much less public scrutiny because federal judges and most state judges live in homes with undisclosed addresses. And cameras are not allowed in the courts according to court rules in the federal courts, and in many state courts, cameras are not allowed. So the public doesn't get to see what's going on unless they take the time and effort to go watch a hearing or a trial. So how do you know if a judge has acted unfairly or has engaged in misconduct? You may feel that a court ruling did not seem fair or know that it was contrary to the facts or the law, but how do you know whether or not the judge engaged in misconduct? What is evidence of judicial misconduct? How are judges supposed to act? The Code of Conduct for the United States judges provides that judges should comply with the law, as well as the provisions of the Code of Conduct. It states that public confidence in the impartiality of the judiciary is maintained by the adherence of each judge to this responsibility to follow the law. And that conversely, a violation of the code diminishes public confidence in the judiciary and thereby does injury to the system of government under law. The code provides that a judge should respect and comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Excuse me. I talk so much about the jury sometimes. Okay, the code provides that a judge should not convey or permit others to convey the impression that they are in a special position to influence the judge, and that a judge must avoid all impropriety and even the appearance of impropriety. The code requires a judge to disqualify himself in a proceeding in which the judge's impartiality might be reasonably questioned, including instances in which the judge has a personal bias or prejudice concerning a party. It requires a judge to be faithful to and maintain professional competence in the law. We've all heard it. Ignorance of the law is no excuse for violating it. And this applies especially when you are a judge. Furthermore, the code requires a judge to give every person who is legally interested in a proceeding the full right to be heard according to the law. The provisions of the code require judges to act in a manner which is consistent with due process, which guarantees us the right to a fair hearing before an impartial tribunal which follows the law. The codes of conduct for state court judges are very similar to the ones for federal or United States judges, as they are also based on these fundamental requirements of due process. Due process also requires the court to have jurisdiction to hear the type of case brought before it. Requires that such subject matter jurisdiction must be invoked by a properly filed petition or complaint naming the parties to the action, and requires that process must be served in order for the court to obtain personal jurisdiction over the parties against whom relief is sought, and in order to notify such parties of the lawsuit. Due process also requires that a party must have the opportunities to be represented by counsel, to have time to prepare, and to be able to call and present witnesses and evidence. Due process is also known as the fundamental fairness doctrine. So what is the law that a judge should follow? The supreme law is the Constitution of the United States, against which all other law must be judged. Then there are statutes and court rules, and there are cases construing them. Judges are required to follow these statutes and rules and the cases construing them issued by superior courts. The Code of Conduct requires it, as do thousands of cases in which superior courts have instructed the lower courts to follow the rules, to follow the statutes, to follow the Constitution, and to follow the cases construing them. So what is evidence of judicial misconduct? Of course, some actions clearly violate the Code of Conduct, such as instances when a judge is caught taking a bribe. However, although judges have been caught accepting bribes, that rarely happens because they are usually not stupid enough to take money from someone who is not part of the Crooked Judges Club. Also, if an attorney or a party is heard bragging about bribing a judge, that should be probable cause to start a criminal investigation of them as well as the judge. But as you can probably imagine, our system has become so corrupt that the authorities have failed to act on even that type of evidence, and have even failed to act on documentary evidence that I have submitted showing the commission of felonies by members of Florida's court system. Unfortunately, in the vast majority of cases, the parties involved in fixing a case will not be so stupid that they will openly brag about their ability to improperly influence a judge, or so stupid that they will leave evidence of the commission of criminal acts visible in the court file. In most cases, the only ways to determine whether judicial misconduct has occurred is by being present when the misconduct occurs, or by reviewing the case file and the transcripts of the proceedings to see whether the judge has ignored the law or the facts to the point that the judge's actions indicate a fundamental violation of due process or an abusive process. What is an abusive process? Black's Law Dictionary defines it as an improper and tortious use of a legitimately issued court process to obtain a result that is either unlawful or beyond the process's scope. However, if a court issues an order or enters a judgment against a person who is not a party to a lawsuit, and therefore a person who the court has no jurisdiction or power over, can you say that such order or judgment has been legitimately issued? Of course not. And if a court does so, it's a prime example of judicial misconduct. They have blatantly exceeded their jurisdiction. In fact, in Florida and many other states, if a judge issues a judgment or an order against a person who is not a party to an action, the judge is personally liable for the damages flowing from such order or judgment. But federal judges, on the other hand, are completely protected from liability for such outrageous actions by the federal doctrine of judicial immunity, which, of course, they created. The Restatement of Torts defines abusive process as use of a legal process against another primarily to accomplish a purpose for which it is not designed. For example, if a judge charges a person with indirect criminal contempt for filing a motion which is allowed by the rules of procedure and allowed by case law, rather than paying a judgment entered against this person, even though the person was not a party to the lawsuit, it would appear that such judge was threatening to use his power to imprison in order to extort money from someone who the judge has no jurisdiction or power over. Of course, that would also fit the definition of malicious prosecution, which is the institution of a criminal or civil proceeding for an improper purpose and without probable cause. You may believe that a judge would not do such outrageous things that I just mentioned, but it has happened in cases that I have been involved in. Although incidents do occur where a judge engages in conduct which indicates that such judge had acted without jurisdiction or has abused his contempt power without probable cause, most of the time the judge will not be so obvious that he's engaging in judicial misconduct. In most cases, you will need to see whether the judge has acted in a manner which indicates that he is favoring one side by ignoring the rules or controlling precedent, or is otherwise acting in a manner which is inconsistent with due process. To do so, you must review the applicable rules of procedure and the cases construing them, so that you're aware of the issues and how the judge should rule on them. For example, if a judge refuses to allow a party to present witnesses in his defense, or refuses to allow a party's witnesses to testify about all matters which are relevant to that party's claims or defenses, then the judge is clearly violating the party's right to due process and is most likely biased in favor of the opposing party. Also, if an appellate court refuses to require the lower court to comply with the rules requiring preparation of the record, and also refuses to allow you to submit documents which disappeared from the record, then the appellate court is ignoring the rules of procedure and appears to be biased in favor of the opposing party. So if a judge has acted in a manner which has unfairly deprived you of due process, what can you do? As Zena said earlier, you could report it to the appropriate authorities in the court system. But the U.S. Supreme Court's own study shows that over 90% of such complaints are dismissed without any investigation. And that disciplinary action is rarely taken in the few cases that are investigated. In Florida, you could report it to the Judicial Qualifications Commission. But those reports are kept secret unless the commission decides to file charges against a judge, which once again rarely happens. And when it does happen, quite often the commission is going after a judge who rocked the boat by exposing improper conduct by another judge. Yes, fortunately, there are judges who have integrity and who will follow the law, but if you're not in one of their courtrooms, you'll be lucky if you find justice. Unfortunately, these commissions are made up of judges, so having them protecting the integrity of our court system is about as successful as having the fox watch the henhouse. And in Florida, it's even worse, because the watching is done in the dark, hidden from public view. You could also report judicial misconduct to law enforcement, like the FBI or the prosecuting attorney. But although action is occasionally taken by law enforcement against corrupt judges, it's rare. You could write your congressional representatives and senators, but Congress has rarely taken action to remove a federal judge. You could write your state legislators, but that also rarely results in any action being taken. You could tell the press, but they almost never report on judicial misconduct unless it involves drunkenness or sexual misconduct, or unless too many people know about it for the press to ignore. You could tell your friends, your family, your co-workers, and those in your church, but you will probably find that many of them are scared to face the truth because they don't want to believe that it could happen to them. Of course, some will be supportive rather than running away. But what can they really do that can help? They can show up for hearings, because judges feel, and I know this from personal experience, judges feel more uncomfortable ignoring the law and the facts when they're facing a crowd. Your supporters can attend a rally at the courthouse. That can really help because it may draw some media attention. But you have to keep it up. You have to keep it up. You have to keep it up. If you're doing one rally one afternoon and you tell every person in the local press, let me tell you, it'll be amazing if it makes the news or the paper. You have to keep it up. There's a woman in Naples, and I practiced law in Naples for a while right after I got out of college, that sat in front of the courthouse with signs about misconduct by a judge for a year before they finally started talking about it in the press. And they had to talk about it because everybody that went to court there saw her for a year. So finally, they started talking about it. By the way, the judge is still on the bench. But at least the public knows. Okay, of course, if your state is one of those states that still allows you to present evidence to a grand jury, then you should put your evidence of misconduct together and try to get an indictment. Although since this route is one that's rarely taken, you will still be fighting an uphill battle. When you are being railroaded, it's really almost too late to do much other than make it as difficult as possible to get run over. So if you really want justice, you need to act now. You can fight to restore your right to petition for a redress of grievances to a grand jury. Once again, if those judges know that you can go into a grand jury and talk about what they did and the law they violated, they're going to quit their corrupt behavior so quick. It'll be amazing. It would transform the country overnight. That's why they took that right away from you, because they did not want the power in the hands of the people. You can also fight to restore your right to a jury trial in all cases, because far too many judges have proven that they are untrustworthy. You can fight to have more public oversight of the judiciary by requiring information on judges' homes and finances to be made public, by requiring video cameras to be allowed in the courts. You can push to make complaints about judges' public record available for all to see on the internet, and to have those complaints reviewed either by a grand jury or at least by a committee that is not made up solely of judges and attorneys. You can take away the power of bar associations to take actions against attorneys without a jury trial.
Yes.
Right now, they take your license away, and it's like a joke because a corrupt judge sits over you. In my case, because they've been going after me for 4 years, I wasn't even allowed to call witnesses in my defense. That's absurd. That's not American. That's more like Nazi Germany, okay? Stalinist Russia, China today, Saudi Arabia today, where the people have no rights whatsoever. They're no more than slaves working and serving those in power. It's disgusting. Most importantly, you can join together and support groups like the National Judicial Conduct and Disability Law Project, the Fully Informed Jury Association, and the Judicial Accountability Initiative Law, and help spread the truth about the problems with the court system. You can contact We the People or the Lawmen to see if they have a court watchers group in your area. And if not, you can start one for your area. You can ask those seeking office whether they support judicial reforms, and you can support the ones who are speaking out about problems with our court system. And I suggest, because I've been representing several people who've been contesting elections in Florida for the last year, and they're honorable people, and they ran as Democrats for Congress, and they got zero money from the party, because unfortunately both parties no longer are interested in the people. They're interested in the money and the power, and they will not support honest candidates that are really serious about reforms. So if you want to support a candidate for office, whether they're Democrat or Republican, don't give the money to the party. Give it directly to the candidate. Take the power, take the money away from those in power. Give it to the people who are telling you face to face they believe in what you believe in. They believe in what America stood for. And they're going to fight for it. Give it to them directly to use. Don't give it to some party who's going to give it to some candidate that's just one of the flags for the powers that be. Nothing but a shill. We have to work together to restore justice in America. Without all of our efforts to raise awareness about these serious problems, our court system is doomed to move further down the path towards that of a third world system. And we and our children are doomed to suffer the dire consequences which flow from a corrupt court system, which include a declining standard of living, increasing crime and violence, consequences which we are already experiencing. Remember, without justice, there can be no peace. If you want peace, take action to restore justice, and do it now. I look forward to working with all of you in this fight, and I truly believe that if we work together, we can get justice in America. Thank you very much for your attention and for your